This is an appeal in the matter of White and 29 Buckland Crescent Management Company Limited.
Yes, Mr Grady.
My lords, my lady, I appear for the appellant, and my learned friend, Mr Bromelo, appears for the respondent.
Yes.
If I could first deal with a few matters of housekeeping. In terms of timing, I anticipate that I should be about an hour and a half, subject to any questions that the court may have.
Yeah.
My learned friend anticipates he may be about 1.5 to 2 hours, again subject to any questions. The court should have, I hope, before it 3 bundles.
We got, or at least one copy of a bundle was handed in this morning, which, just looking at the index, looks as the same as the ones we had before. I don't know what, if anything, is different about it.
It may have been that was the direction of the court to bring a hard copy with us.
Oh, I see.
My lord, I think. That's correct, my lord.
Right.
So nothing new in that bundle, certainly, my lord. So, my lord, firstly, there should be the core bundle, which has the page numbers CB at the bottom right-hand corner. That's the core bundle. Secondly, there's the supplementary bundle.
Yeah.
Thirdly, the agreed authorities bundle.
Yeah.
And then there are the 2 short supplementary skeletons.
Yes, about the 38 Act.
Which I don't think we need to take the court to.
No. Well, I mean, we may need to come back to the 38 Act in due course, but can I, just before we go any further, put what may be a new point to both of you, see what your reaction is. If we look at the core bundle, first of all, we've got the settlement agreement.
Tab 14, my lord.
Yeah.
Yes.
And that says in clause 7.2 that clause 6 and clause 7.1 shall not apply to claims in respect of any breach of this agreement, and I take that to mean breach of the settlement agreement. And if we then look at the lease, which is in the supplemental bundle, we have clause 5 of the lease, which is on page 11, and that is the forfeiture clause, and it says that if the rent is in arrear, or if there shall be any breach of any covenant or agreement on the part of the lessee herein contained, which I take to mean contained in the lease.
Yes, my lord, it can only mean that in my submission.
So my question is, how does the forfeiture clause, which arises on breach of covenant in the lease, extend to a breach of a different agreement, namely the settlement agreement?
Well,
Now,
in my submission, my lord,
that gives rise, sorry, let me just carry on. That gives rise to 3 points, 3 questions rather. The first is, do you wish to take the point? It's not been taken hitherto, so it's a new point. Second question is, if you do wish to take it, should we let you? Bearing in mind it's a new point. And the third question is, if we do let you, is it right?
well, could I trouble your lordship just to explain the point one more time, because I'm not quite sure I'm
Right.
I follow.
Clause 5 allows the landlord to forfeit for a breach of covenant herein contained, i.e. in the lease.
Yes.
Clause 7.2 allows the landlord to sue for a breach of an obligation in the settlement agreement. So you've got the lease on the one hand and the settlement agreement on the other. So how does the clause which says you can forfeit for breach of the lease allow you to forfeit for breach of the settlement agreement? That's the question.
Yes, I see, my lord. Well, obviously, it's not a point that's been taken.
No, exactly.
To date, but this may go back to the judgment of His Honour Judge Dight, where he said, if it had been intended by the drafters of this agreement for a breach of the lease to give rise to a right to forfeit, it would have had to explicitly say so, and that of course it doesn't. It doesn't say that, and so that's why we say that forfeiture is not permitted by way of a breach merely of 7.2.
Yeah.
So I suspect, my lord, that we arrive at the same answer.
So you're saying this is a point that was taken before?
Well, certainly in the judgment of His Honour Judge Dight, he alludes to what I think is pretty much the same point, my lord.
Yeah. Right.
So I think we'll come on to that later.
Well, we'll see if Mr Bromley's got any objection to this way of putting it.
Now, my lord, or later?
Well, whatever's convenient to you, Mr Bromley.
If I may, I'll wait to see how Mr O'Grady puts his submissions before responding to them. I'm happy to deal with the point which your lordship raised.
Right.
Because I think I may be able to clarify our position at the very least.
Right.
Our position is that the forfeiture, the landlord was not entitled to forfeit simply because of a breach of the agreement. You can, of course, have, for example, in a licence of alterations, a provision saying that a breach of the licence shall give rise to a right to forfeit, and so that it's brought within the scope of the forfeiture clause. And I would accept, of course, there's no equivalent provision in the settlement agreement. So I am not arguing, and have not to date argued, that a breach of the settlement agreement can itself give rise to a right on the part of the landlord to forfeit under the proviso for re-entry. What I say is that we were entitled to forfeit in this case because the matters complained of, the failure to put the shower room in repair, were both a breach of the settlement agreement and a breach of covenant in the lease.
Right.
The fact that they were a breach of covenant in the lease meant that we could forfeit. The fact that they were a breach of the settlement agreement, we say, brings it within the scope of clause 7.2, and that, of course, is the primary issue for this court to determine.
All right.
My lords, my lady, I intend to structure my submissions into three areas. First, I will take the court through the key terms of the settlement agreement, which I will submit as a straightforward document with a clear and obvious purpose, and that it does not require complex interpretation. This would include an overview of the three FTT applications as contained in the supplementary bundle. Secondly, I will address you on what I propose to term is the Clause 4 issue, together with the two authorities addressing the question of why a landlord may potentially seek a determination in the FTT of a breach under Section 168 of the Common Hold and Leasehold Reform Act 2002, or otherwise seek an admission in relation to the same. And then thirdly, I will seek to persuade you that the decision of Mr Justice Richards was wrong and that the reasoning of His Honour Judge Dight was right.
Yes.
So first, turning to the key terms of the settlement agreement and what I say is the straightforward way it is to be interpreted. If the court could please turn to the core bundle, the settlement agreement is behind tab 14. And if the court could please turn to page 128. In terms of what was being settled by the settlement agreement, there are two main matters that were being settled. The first is the dispute that's referred to in recital A, which comprises the three sets of FTT applications. These are collectively defined as the proceedings with a capital P. The second dispute that was settled concerns matters related to the leaseholder's claim under the building's insurance policy, and this is referred to in recital B, quote, in respect of the repairs required to the bathroom of the property, quote, the works. So in order to understand what was precisely being settled in relation to the FTT proceedings, may I refer the court to the supplementary bundle. Tabs 2 to 4 contain the three applications that the landlord made to the tribunal, and they're each dated the 24th of May 2021. The first application is behind tab 2, and that is an application which I've quoted from in my skeleton argument at paragraph 11, and it's headed Application for an Order that a breach of covenant or a condition of the lease has occurred. And if you turn to page 30, we can see here in box 13 what is said to be the reason that the application is being sought, namely that clause 3.1 of the lease has been breached because, and I quote, the shower room in the respondent's flat is not in good, substantial and tenantable repair, and has caused multiple water leaks into the flat below, and hence the respondent is in breach of clause 3.1. So in this first application, no money was sought. The application merely sought a determination that there had been a breach of clause 3.1 of the lease in relation to the bathroom. The second application is then behind tab 3.
But how do you ask for money in the FTT? Doesn't have power, does it, to give a judgment? Money judgment?
Your Lordship will see in paragraphs, in the applications that sit behind tabs 3 and 4, those are applications for determinations of money that's being sought.
Yes, indeed, but they're only determinations.
Yes, sought in...
You can't get a money judgment out of the FTT.
Yes, my Lord. But one might, if one wanted to go and get a county court judgment,
Yes,
one may need first to get a determination.
Yes, absolutely.
So sought in the sense of a preparatory and necessary first step. So the second application is headed application for a determination of liability to pay and reasonableness of service charges. And turning to page 37, box 7, we can see there that the service charges to be considered by the tribunal were in relation to 2020 and 2021. Then at the bottom, it states the total value of the dispute, £24,677.88. The breakdown of that figure is then provided at pages 49 in relation to 2020, and then page 50 in relation to 2021. And the total of all of those figures on page 49 and 50 equals within £1 the figure that was stated in box 7 at page 37 of £24,677. So in relation to the third application, that's then behind the fourth tab, and that is headed application for a determination as to liability to pay an administration charge or for the variation of a fixed administration charge. Then turning to page 82, the page is headed administration charge details. Towards the bottom of the page, it then says the grounds of the application. It says the respondent has failed in breach of clause 3.1 of his lease to keep the shower room in his flat in repair. As a result of the said failure, the applicant has served notices to repair on the respondent, carried out inspections and works to abate the nuisance caused by the lack of repair, and has incurred legal costs in relation to the respondent's failure to keep his flat in repair. A demand was made for reimbursement of those costs pursuant to the above clauses of the lease. Those are the clauses in the box above. On 31st of July 2020, in the sum of £9,027, but the respondent has failed to pay the same. The applicant therefore seeks a determination of the respondent's liability to pay the said sum as an administration charge. Then it says at the bottom, please also see attached continuation sheets 1 and 2, setting out details of further administration charges. If we then turn to page 85, this is the first of the 2 continuation sheets. We can see there towards the bottom of the page, it's the penultimate box.
Yeah.
And it's the third sentence. A demand was made for reimbursement of those costs pursuant to the above clauses in the sum of £1,008. Again, it's legal costs. And then turning to the second continuation sheet, that's at page 87. Again, second sentence, reference to legal costs. Then the third sentence, a demand was made for reimbursement of those costs pursuant to the above clauses in the lease on the 15th of November 2020 in the sum of £1,123. So, adding up those
How do they add up to 9,000?
They don't, my lord. 9,000 is the principal sum, to which we have to add the sums in the 2 continuation sheets. So when one adds up those 3 figures, one gets to £11,158. So, my lord, my lady, if we take the total amount sought in the second application of £24,677, and we add that to the sums that are sought in the third application, we have a grand total sought across all 3 applications of £35,836, so just shy of 36,000. out of which in the region of £11,000 was sought in respect of the administration charges in the third application, and the majority of those comprised legal costs. So for example, we can see at page 94, there is an invoice here from Teacher Stern, the total of which is £5,703. And then similarly at page 100, again, another invoice from Teacher Stern, £2,184. So, as I say, the total that was sought by the landlord in terms of determinations across these three applications was just under £36,000, including roughly £11,000 of legal costs. And I sent my learned friend the breakdown of those figures last week, and we've agreed that the arithmetic in that respect is correct.
Right.
Now, of course, the respondent will no doubt say that the £36,000 principal sum in those three applications did not include all of the legal costs of the landlord, down to and including the final hearing before the FTT. However, as the court is well aware, the FTT is generally a no-costs regime, as noted in the judgment of my Lord Lewison in the East Point Block A Right to Manage Company and Ochubaga case, which is in the authorities bundle at tab 2. The page reference is page 11, paragraph 27. Now, nowhere in any of the three FTT applications does the landlord state in terms that it will be seeking further legal costs associated with the FTT proceedings beyond those that were detailed and specified in the third application. And so I say it's unlikely that costs would have been awarded in the end before the FTT. The second matter that was settled apart from the FTT proceedings related to a dispute concerning a claim that Mr White had brought under the building's insurance policy. So turning back to the core bundle and the settlement agreement at tab 14, recital B says, Party A is the holder of an insurance policy with Allianz for the building, the insurance policy. Party B has made a claim against the insurance policy in respect of the repairs required to the bathroom of the property, defined as the works. So whilst we don't have much further about the background of this dispute in the settlement agreement itself, in my submission the position becomes clear when the court considers clause 3, page 129, which states Party A, so that's the landlord's obligations, Party A will not take any action which may jeopardise Party B's present claim against the insurance policy in respect of the cost of the works. For the avoidance of doubt, Party A will be under no obligation whatsoever to support Party B's claim against the insurance policy or cooperate with Party A or the insurer in respect of the aforementioned claims. For the further avoidance of doubt, the clause will not preclude Party A from disclosing this agreement or providing any details as regards the works or disrepair in the event that it receives such a request from the insurer. So my submission, it's tolerably clear from clause 3 that there must have been a dispute between the parties concerning whether the landlord would object to that claim being made, which is why the landlord agreed under clause 3 not to interfere with Mr White's claim. And on the 6th of January 2022, Mr White received a payment of just over £9,000 from the building's insurer in relation to the bathroom claim, and this payment was referenced in the judgment of His Honour Judge Dight at paragraph 47 of his judgment. The page reference is 116. So this settlement agreement is concerned not only with the settlement of the 3 FTT applications, but also evidently settling a dispute or potential dispute concerning Mr White's claim under the building's insurance policy that was in the process at the time the settlement agreement was entered into in connection with the works necessary to put his bathroom back into repair, effectively the installation of a new bathroom. Turning now to the obligations under the agreement and leaving aside for a moment the general release and the agreement not to sue, which are of course central obligations and which I will come back to, leaving those aside, Mr White's other primary obligations were threefold. So at page 129, at first, under clause 5.1, he had to pay the total sum of £75,000 in 2 instalments. Secondly, under clause 5.3, he had to remedy the breach of clause 3.1 of the lease by carrying out the work. And thirdly, also under clause 5.3, he had to complete the works by the deadline 28th of January 2022. The express wording of clause 5.3 makes clear that, by undertaking the works, Mr White would thereby have remedied the earlier breach of the lease that he admits at clause 4 of the settlement agreement. The two clauses, clause 4 and clause 5.3, are therefore to be read together. The inclusion of the admission at clause 4 functions to make the obligation in clause 5.3 intelligible and makes clear that, by executing the works, Mr White will at that point also be in compliance with the terms of his lease as regards the state of his bathroom. And the court will note that His Honour Judge Dight found that the obligations to undertake the works went beyond mere compliance with the terms of the lease. So if the court will please turn to the judgment of His Honour Judge Dight at tab 12, and it's page 120.
Yeah, that was paragraph 76, was it?
78.
78.
76 may also be relevant. If I could just invite the court to read paragraph 76 to 78.
Yeah. Yes.
So the finding of His Honour Judge Dight that the works went beyond those required by the demands merely of the repairing covenant has not been appealed, and therefore in my submission that finding stands. Concerning the admission at clause 4 and its relationship with the obligation at clause 5.3, His Honour Judge Dight held at paragraph 81 of his judgment, that's at the bottom of the page, and then over the page, and it's after the first semicolon, where he says, and secondly, it is an admission that the bathroom was in a state of disrepair in breach of covenant, which was a peg on which to hang the obligation to remedy the breach which follows in clause 5.3. And that, my lords, my lady, I say is right. The wording in clause 5.3 concerning the breach of the lease can be readily understood when read against the admission contained in clause 4. And this is what His Honour Judge Dight meant by saying that clause 4 was the peg on which to hang the obligation in clause 5.3. Now, as I've already mentioned, separately from the general release and the agreement not to sue, the landlord's other main obligations under the settlement agreement was contained in clause 3, which was essentially not to stand in the way or interfere with Mr White's claim under the building's insurance policy. So that obligation not to interfere with the insurance claim was something that was separate and distinct from the obligations concerning the settlement of the FTT proceeding. So then turning to the other core obligations of the settlement agreement, these are the general release at clause 6 and the agreement not to sue in clause 7.1 in relation to the causes of action in the underlying FTT proceedings. And those are page 130. So clause 6 is the general release, and it's in the following terms. This agreement is in full and final settlement of, and each party hereby releases and forever discharges all and or any actions, claims, rights, demands and set-offs, whether in this jurisdiction or any other, whether or not presently known to the parties or to the law, and whether in law or equity, that its related parties, or any of them ever had, may have, or hereafter can, shall, or may have against the other party, or any of its related parties, arising out of or connected with the proceedings. It is by those words, a widely drawn, I say, general release, which the landlord accepts would preclude a claim for forfeiture based on the extant disrepair of the leaseholder's bathroom, absent, of course, clause 7.2. Clause 7.1 is then an agreement not to commence, quote, any suit or other proceeding concerning the proceedings. Again, in my submission, that is a widely drawn clause. And that these clauses are widely drawn is entirely usual where parties are seeking to achieve a release on wide terms. These two obligations are core obligations because without them, nothing would have been settled at all. They are clauses in an entirely standard form, such as one would see in a typical settlement agreement that contains a wide release. The landlord's position is that without the inclusion of what it says is the gateway clause of 7.2, it would have been precluded from pursuing forfeiture, given the wide release at 6 and the agreement not to sue at 7.1. This is cited in the judgment of His Honour Judge Dight at paragraph 88. The page references core bundle, page 122, paragraph 88.
Which paragraph? Judge Dight?
Page 122, my lord, paragraph 88. But he says, in the claimant's skeleton argument of paragraph 14, it was submitted that clauses 6 and 7.1 would by themselves prevent the landlord from bringing the instant proceedings, and it was submitted and accepted in oral argument that in the absence of clause 7.2, the claimant could not bring the claim because it arises out of or is connected with the proceedings. The defendant obviously did not disagree with that statement or concession. So my learned friend says, at paragraph 39 of his skeleton, that it would have made no commercial sense for the landlord to have given up its right to forfeiture of the lease based on the outstanding breach of the repairing covenant. The page reference is page 45. Page 45, paragraph 39. However, in my submission, that proposition entirely ignores what the parties were doing. They were agreeing to compromise to settle their differences on a, quote, full and final, unquote, basis, as is set out at recital C to the settlement agreement. As is usual in settlement agreements, both sides tend to give up something in exchange for drawing a line underneath the dispute at hand, and I say that is what happened here. Moreover, the commerciality of the arrangement is entirely obvious. The landlord was obtaining a substantial payment of £75,000 in settlement of the 3 FTT applications. And as I set out earlier, the total amount of money that was sought to be determined in those 3 applications was just shy of £36,000. Only if the landlord, in my submission, could have hoped to rely on unreasonable conduct on the part of the leaseholder, could it have hoped to obtain from the FTT any award of legal costs beyond those that were set out in the FTT applications themselves. So the £75,000 was more than double the total sum that had originally been sought. The landlord was being paid handsomely in return for compromising its 3 applications in the FTT, as well as, we say, the right to forfeit based on the disrepair to the bathroom. And the commerciality of that, I say, lies in the very substantial payment of £75,000, which he undertook to pay, and he did pay. Forfeiture, following a determination of breach by the FTT, was plainly something that might have followed absent settlement.
Well, I just want to ask you about that. The Leasehold Property Repairs Act 1938 runs along in parallel with Section 168. Section 168, if you get a determination of breach, allows you to do no more than serve a Section 146 notice. Once you have served a Section 146 notice, the way is open for you to apply to the court if the lessee doesn't serve a counter notice. Now we know for reasons which I can't begin to understand, Mr White didn't serve a counter notice, and if he had done so, then he would have saved himself an awful lot of trouble. But he didn't. But standing at the moment when the settlement agreement was made, anybody who had heard of the 1938 Act would have thought the chances of actually forfeiting were vanishingly small. You've got a 999-year lease, very valuable lease, very restricted grounds on which you can forfeit in section 1.5 of the 1938 Act. On the face of it, none of them are made out. So what is this whole idea about preserving the right to forfeit? It seems to me to be largely illusory.
Well, my lord, it was sought on the part of the claimant in this matter, the landlord, at trial, that it did want forfeiture all the way up until trial, because my learned friend and I were trial counsel.
Well, I know, but I know that, but that's because they got a windfall because Mr White didn't serve a counter notice.
Yes.
But if you were looking at it at the moment of the settlement agreement, it seems to me to be unrealistic to suppose that anybody entering into that settlement agreement would have thought that, despite the fact that you're told you can serve a counter notice, you wouldn't.
Yes, well, I understand Mr White had different solicitors at that point. So we know not.
Yeah.
As I say, but without the settlement agreement, my lord, is what I'm saying, is that if we hadn't had the settlement agreement, plainly the landlord might have continued and served a section 146 notice. And this settlement agreement, I say, sought to draw a line under the matters in dispute, which is what recital C says.
Yeah.
That's what they're doing. So foregoing the right to forfeit, of course, did not leave the landlord in this case without remedy in the event of subsequent breach, since new causes of action arise from the existence of the settlement agreement itself. If Mr White failed to comply with any of the terms of the agreement, the landlord could have sued on the agreement itself, whether in debt, for damages, specific performance, or an injunction. And the landlord would have been entitled to its costs on the indemnity basis, as provided by clause 10.2. So the landlord was in the position of possessing new causes of action that flowed from the settlement agreement, which included the right to indemnity costs for any breach by Mr White. That clearly gave the landlord, in my submission, a very big stick with which to enforce the strict terms of the agreement, if, of course, it had chosen to do so, which it didn't in this case. In terms of the admissions that are contained in the settlement agreement, the court will be well aware that some settlement agreements contain admissions, others don't. In this settlement agreement, it's apparent that the drafters were careful to include clauses about admissions, not only for the leaseholder, but also for the landlord. So if we turn back to the settlement agreement tab 14, page 129, at clause 4 we have the admission for the leaseholder, which I won't trouble the court with again. But then at page 131 at clause 11, we then have what is headed no admission. This agreement is entered into in connection with the compromise of disputed matters, and in the light of other considerations, it is not and shall not be represented or construed by the landlord as an admission of liability or wrongdoing. Shall not be represented or construed by the leaseholder, as an admission of liability or wrongdoing on the part of the landlord to this agreement or of any related party. So whilst the landlord is at pains to stress that there must be a legal consequence of the inclusion of clause 4, the admission on the part of Mr White, that he was in breach of the terms of his lease, that is not consistent with the no admission at clause 11. There is in my submission obviously no legal consequence of a non-admission. Had clause 11 not been included in the settlement agreement at all, the agreement would have meant precisely the same as with it included. Clause 11 might be compared with a clause that contains the words for the avoidance of doubt. And for example, if we turn back to page 129, I took the court to it earlier, clause 3 has two such for the avoidance of doubt sentences. We have the second sentence, for the avoidance of doubt, party A will be under no obligation whatsoever to support party B's claim. Then the next sentence, for the further avoidance of doubt, this clause will not preclude party A from disclosing this agreement. In my submission, contracts often include clauses that are superfluous or overlapping. Contracts such as this are not the product of the parliamentary drafting team. And the proposition that every single clause in a commercial contract such as this must have a legal consequence is plainly wrong as a matter of law. A contract such as this is not to be interpreted in the same way, obviously, as a statute. I've cited in the authorities bundle, in the third tab, the case of Total Transport Corporation and Arcadia Petroleum Limited. If I could just turn the court to that authority. It's at the bottom, it's the highlight, it's the section in red track lines at the bottom of page 27 and over the page to 28. If I could just invite the court to read those two passages.
Sorry, just a minute, my bundle's full of bits. 27 to 28.
Yes, my lord.
Yeah.
And so those passages are authority for the proposition that the rule against surplusage or superfluity is of little or no application in the construction of a commercial contract such as this.
Nowadays it seems to be called the argument from redundancy.
I'm grateful, my lord. So, in terms of the quality and nature of the drafting of this settlement agreement as a whole, it is clear in my submission that the document cannot be considered the product of particularly careful drafting. I shall set out some examples. As a first example, we have the fact that there is, of course, no detail as to what the works actually comprise, save for the wording provided in recital B, page 128, which simply refers to the works as being, quote, the repairs required to the bathroom of the property, which was the subject of the insurance claim. But that, of course, begs the question, what precisely were the works that were required? There's no schedule of those works. There's not even a specification. Secondly, we have clause 1, which is supposed to comprise a set of defined terms, yet it only includes a single defined term, being related parties. Clause 3 then includes the term disrepair with a capital D, and yet that is not in fact a defined term under clause 1.
Sorry, which clause? 3, did you say? Oh yes, I see. The works all disrepair. Yeah.
Yes. Yes, page 130, my lord. So then, turning to page 130 in clause 6, this is in the release. The release says, this agreement is in full and final settlement of, and each party hereby releases and forever discharges all and or any actions. Well, what is of course meant there is and. It can't be meant to be or at all. And the use of the words and or is often criticised as being open to fundamental objections in my submission of inaccuracy, obscurity, uncertainty, or even just being plain meaningless. As a fourth example, clause 2 itself, headed page 129, effect of this agreement, the parties hereby agree that this agreement shall immediately be fully and effectively binding on them. Well, that clause plainly adds nothing at all to the terms of the settlement agreement, as if it didn't have it.
Well, let's assume you're right, this is not a well-drafted document. Where does it take you?
Well, the point, my lord, is that the court must construe the written agreement of the parties with all its imperfections and infelicities, rather than to find a different agreement that the parties maybe should have entered into, but in fact did not.
Well, for sure, yes. I mean, we have what we have, and we must try and understand what it means.
So my primary submission then as to interpretation is that there is simply no need to look beyond the clear words of the agreement for any particular or hidden consequence of clause 4 beyond the obvious relationship it has, as I say, to clause 5.3. Clause 4 aids in understanding what clause 5.3 means against the clear wording of the general release and the covenant not to sue. However, it can't, in my submission, do what the landlord is claiming it does, namely preserve a right to forfeit, which is excluded by the clear words of clause 6 and 7.1. The drafters of this settlement agreement were clearly concerned with admissions. The landlord wanted to make clear that they had done no wrong, clause 11, and it was made clear that the entirety of the fault lay with the leaseholder, clause 4. The fact that those admissions and non-admissions may have had no legal consequence does not mean that the court should try to find one. Turning to clause 7.2,
Why does the admission not have a legal consequence? Leaving aside clause 6 and 7.
because
it would, wouldn't it? Because the admission would give the landlord, absent clauses 6 and 7, the right to serve a section 146 notice.
Taking clause 11, my lord, there's no legal consequence.
No, I follow, but
Yeah.
you were referring to clause 4.
Yeah, but that is our case, that in this case, it doesn't necessarily mean that that is an admission for the purposes of section 168 and that a right to forfeit is preserved, because it would have needed to expressly say so. So we say that there is no legal consequence of the inclusion of clause 4. I'll come on to that a little later. So 7.2 is at page 130, and it says clause 6 and clause 7.1 shall not apply to any claims in respect of any breach of this agreement. And in my submission, it's self-evident that the formulation of the words in respect of, used in clause 7.2, is of narrower effect than the formulations arising out of and connected with, which appear in clause 6. And as I set out in my skeleton argument at paragraph 35 onwards, that's in the core bundle at page 27 if you need the reference, the effects of the word in respect of, used in clause 7.2, is to contain the scope of the exception from the agreement that neither party may sue the other, save in respect of the breach of the agreement itself. I say that the narrowness of this exception is essential to the purpose and effect of the settlement agreement, in order that the proceedings are effectively compromised and that the dispute does not revive. And in my submission, in order for the words in respect of, at this point of the settlement agreement, to provide for a wider exception to the agreement not to sue would require clear and specific words. Otherwise, the very purpose of the contract, to compromise the pre-existing causes of action, would be defeated. In the context of a settlement agreement, the words "a claim in respect of any breach of this agreement" can, in my submission, only mean a claim for any breach of this agreement. Obviously, the parties to a settlement agreement are always entitled to sue for breach, and this clause was doing no more than making that entitlement abundantly clear. It is simply another example in the agreement of a "for the avoidance of doubt" type clause, as I've taken the court through. But in the absence of clear words to the contrary, there can be, in my submission, no wider right to sue on a settlement agreement other than for breach of the agreement itself. No other interpretation of my submission would make any common or commercial sense. So, for example, if the leaseholder had not paid the £75,000, the landlord could have sued in respect of that sum, sued for that sum. Similarly, the landlord would have been entitled to bring a claim for specific performance, requiring the leaseholder to undertake the works by the deadline, if the deadline had passed. So, my lords, my lady, those are my submissions on the terms of the settlement agreement and how it operates. My primary case is that the court is the court only needs to be concerned with the clear and obvious meaning of clause 7.2,
Right.
and that there simply is no reasonable debate as to what its proper construction is. Concerning clause 4, the drafters of the agreement were careful to include admissions and non-admissions, which I say did not necessarily have any consequence. Now, if the court is not persuaded on my primary submissions on clause 7.2, that it's right as a matter of construction from first principles, then I intend to show that in any event, the landlord's contention concerning what clause 4 must mean is nevertheless wrong. So turning to the second set of submissions, what I have proposed to refer to as the clause 4 issue.
Yeah.
My learned friend says at paragraph 36 of his skeleton, and it's at page 44 of the main bundle, tab 4, page 44. The settlement agreement should of course be interpreted in light of the factual matrix which existed at the time it was executed. At the time it was executed, the respondent was pursuing a claim under section 1684 of the 2002 Act against the appellant. The only legal effect of that application, if successful, would have been to enable the respondent to bring forfeiture proceedings.
Well, that's wrong, isn't it, in the light of the 38 Act?
Well, I say it's in particular it's wrong also, my lord, because of the authority of Paragon and Asra Housing, which my lord cited with approval in the subsequent case of East Point and Ochubaga. So if we could turn to that case, my lords, my lady, it's in the authorities bundle at tab 4. This was a decision of the Upper Tribunal Lands Chamber, and in Bedford it was argued on behalf of the leaseholder that the only possible reason that a landlord might seek a determination under section 168 of the 2002 Act was in furtherance of an intended claim for forfeiture. And that argument was roundly rejected by the Upper Tribunal, and the key findings at page 51 from Martin Roger KC are at
Sorry, where are you?
Page 51, my lord, tab 4 of the authorities. It's paragraphs 46 and 47.
Yeah.
If I could just invite the court to read those passages.
Yeah.
So the Upper Tribunal held that forfeiture is not the only relief that a landlord may want to seek consequent on a determination under section 168. Other possible objectives include wanting to go on to make a claim for damages, or perhaps obtaining an injunction.
Yeah, I think we said that in East Point, didn't we, at paragraphs 38 and 45?
Yes, well, I'm grateful, my lord. I was going to take my lord to his lordship's judgment in that case next, and indeed paragraph 38. So it's at page 13 behind tab 2. That is exactly what your lordship confirmed, where this court confirmed. Paragraph 38 said, it is true that section 168 is concerned with paving the way to forfeiture, but an application to the FTT under 1684 is not itself a proceeding for forfeiture, may be a necessary precondition to the exercise of a right of forfeiture, but it's a discrete and separate step. The mere fact that the FTT has found the existence of a breach of covenant may itself persuade the tenant to cease activities complained of, or remedy the breach without the need for further action. Alternatively, it may be, for example, be the prelude to obtaining a judgment from the county court for an injunction or damages or a charging order, or enabling the landlord to serve a notice under section 146. And your lordship's judgment the judgment of Lady Justice King,
Andrews,
Lady Justice Andrews, I'm
45.
Paragraph 48.
Yeah.
Where she similarly held, these cases demonstrate that despite the fact that section 168 appears under the general heading forfeiture of leases of dwellings, although a determination under section 1684 may be a step on the path to forfeiture, that is not its sole function. In making an application under section 1684, the applicant is doing no more than seeking to obtain a determination by a specialist tribunal that may be used for a number of purposes, including but not limited to the service of a notice by the landlord under section 146. So, my lords, my lady, the principle that there are multiple possible reasons why a landlord may seek a determination under section 168 or an admission in relation to the same has been recognised by this court in the case of Ochubaga. The landlord's case that there is only one possible legal consequence of such a determination is therefore, I say, simply wrong. There are at least 5 possible different motivations for why a landlord may seek a determination under section 168 or an admission. 1, to persuade the tenant to comply with their obligations. 2, to obtain an injunction. 3, to sue for damages. 4, to obtain an injunction. Or 5, to then go on and serve a section 146 notice and go on hopefully to forfeit.
Can you just repeat 2 and 4 again?
2, my lord, was to obtain an injunction.
4?
4 was to obtain declarative relief.
Declarative relief, thank you.
So, if clause 4 of the settlement agreement was intended to preserve the ability of the landlord to pursue at court either injunctive relief or damages or declarative relief or forfeiture, all in relation to the admitted disrepair of the leaseholder's bathroom, then in my submission, the settlement agreement would have settled nothing at all. Such an outcome would be plainly an absurd result, and not one that the objective parties, standing in the shoes of the landlord and leaseholder in this case, could have possibly intended to be the result of them having entered into a settlement agreement and having, quote, settled their differences. Such a preservation of all of those remedies consequent on the same disrepair would have rendered the settlement agreement a nullity. Nothing would have been settled at all. My learned friend argues in his skeleton argument, and it's back to the core bundle.
The judge wasn't referred to these cases under 168, as far as I can see.
No, my lord, they are consistent with what His Honour Judge Dight found, which is that, but no, it's correct that I wasn't aware of the case, and neither my learned friend, so they weren't cited below. So in my learned friend's skeleton argument behind tab 4, page 47, page 46. What my learned friend says, paragraph 43, is, as noted in paragraph 35 above, and as recognised by Mr Justice Richards in paragraphs 48 to 53 of his judgment, there might be other possible motivations for a landlord seeking an admission of breach under section 168. While the decision in Bedford also makes this point, it was one which the appellant accepted at the appeal hearing, and one which Mr Justice Richards acknowledged. Bedford and Paragon does not undermine Mr Justice Richards' judgment, it is entirely consistent with it. The fact remains that, as set out by Mr Justice Richards in detail, at paragraphs 45 to 59 of his judgment, the most obvious reason for the inclusion of clause 4 is because it was intended to give the respondent the right to forfeit if the appellant's breach was not remedied. And it must follow from that intention that the parties intended the exception in clause 7.2 to cover forfeiture proceedings based on the admission of breach, which was the result of the section 1684 application. Well, my learned friend's argument that the case of Bedford is consistent with the judgment on appeal is obviously wrong. If the court could please turn to core bundle page 102, that's behind tab 11. this was my learned friend's skeleton argument before Mr Justice Richards. And at paragraph 26, page 102, paragraph 26, the argument was put as follows. The settlement agreement should of course be interpreted in light of the factual matrix which existed at the time it was executed. At the time it was executed, the appellant was pursuing a claim under section 1684 of the 2002 Act. The only reason for doing so would have been to enable the appellant to bring forfeiture proceedings seeking to forfeit the respondent's lease. There could be no other reason for the appellant pursuing that application. Well, I say obviously that's wrong when set against the decisions in East Point and Bedford. The landlord's case at trial and before the High Court was that there was only one possible consequence of a landlord seeking an admission under section 168. However, there are other possible reasons. The landlord's modified position now is that it is the most obvious consequence, and that is a position that has shifted. And I say it has shifted when faced with the insurmountable hurdle of the reasoning from the Ochibaga case.
Does it matter if they've shifted their position slightly?
Well, the core point that I seek to persuade the court of is that if there is ambiguity concerning what clause 4 might have been intended to achieve, and if in fact it could have achieved multiple different things, then if there's ambiguity in the clause, given that the clause was inserted for the benefit of the landlord, then contra proferentum it must be construed, the ambiguity must be construed against the landlord and in favour of the tenant's interpretation. And the tenant's preferred construction on this point is that nothing turned on clause 4 at all, in the same way that nothing turned on clause 11. And in the same way that nothing turned on for the avoidance of doubt clauses. So, moving on to my third set of submissions, my lords, my lady, I now turn to show why the learned judge below erred in his decision. If the court could please turn to the judgment of Mr Justice Richards behind tab 7. The judge deals with the natural reading of clause 7.2 between paragraphs 33 to 40. Now, as I've already said in my earlier submissions, in my submission, the words in respect of are entirely clear in the context of clause 7.2. And those words essentially mean, as I've said, a claim for. One could read in the word for arising out of. In respect of. So, for example, if the court was considering a claim for service charge arrears in respect of calendar year 2025, there would be no doubt as to what was meant by that. It would be a claim for service charge arrears in respect of calendar year 2025. It would be a claim for the 2025 arrears. Similarly here, a claim, quote, in respect of any breach of this agreement means a claim for any breach of this agreement. So that might be a claim for a declaration of breach that the bathroom was not fixed by the required date, perhaps also a claim for damages for breach of the agreement, perhaps an injunction for specific performance to ensure that the works were completed, bearing in mind, of course, that the findings of the trial judge which have not been appealed were that the works required under the settlement agreement went beyond mere compliance with the terms of the lease. In essence, a new bathroom was being installed. If Mr White, of course, had not paid the £75,000, the landlord could also have issued a claim in debt. Those would all be examples of claims that were in respect of a breach of the settlement agreement. And as I set out in my skeleton argument before Mr Justice Richards, it's at page 81 behind tab 9, and it's paragraph 37, page 81, paragraph 37, I argued In this case, there simply is no reasonable argument for the wide interpretation that the appellant contends for in relation to clause 7.2. The wording at issue here, clause 6 and clause 7.1 shall not apply to any claim in respect of any breach of this agreement, is not in any way ambiguous and does not give any rise to reasonable debate. That is the context in which it is said, if the landlord wanted to preserve a right to forfeit, notwithstanding the widely drafted general release at clause 6, then the parties would have needed to spell that out. And so my primary submission is that Mr Justice Richards was simply wrong to embark on the iterative approach that he did. And it is also instructive to note what clause 7.2 does not say. It does not say that clauses 6 and 7.1 shall not apply to any breach of the terms of the lease. If it had said that, then again the settlement agreement would unravel, since it would mean that the landlord could still have pursued any relief, forfeiture or otherwise, consequent on the very same disrepair that gave rise to the original causes of action, which had been settled by the agreement. So that is another inherent reason, I say, as to why clause 7.2 is necessarily restrictive, as otherwise the settlement agreement simply wouldn't be operative. In my respectful submission, the learned judge erred in paragraph 36 by not finding that clause 6 constituted a broad release, and likewise clause 7 a broad agreement not to sue, and clause 7.2 being a narrower class of exceptions to those clauses. In my submission, 7.2 is plainly narrower, since it is a subset of exceptions to the otherwise broad categories of general release and agreement not to sue. It has nothing to do with the number of words used, but instead it is what those words mean as a matter of ordinary language. In my submission in paragraph 37 of his judgment, the learned judge similarly erred by not appreciating the significance of the opening words of clause 7.2, which read, clause 6 and clause 7.1 shall not apply to any claims in respect of a breach of this agreement. The opening words make clear that this clause is a carve-out clause, carving out a subset of claims to which the broad categories of claims contained in 6 and 7.1 do not apply. The judge held at paragraph 37 of his judgment that this was a question of comparing apples with pears, but that is wrong. Clause 7.2 is merely a subset of the larger set of claims that clauses 6 and 7.1 would otherwise preclude. In my submission as regards paragraph 39 of the judgment, the learned judge similarly erred here by not appreciating that the very nature of clause 7.2 was to provide an exception to the broad releases of clause 6 and 7.1, an exception which was by its very nature narrow. And had the learned judge in my submission appreciated the inherent narrowness of the nature of this exception clause, he would have been bound to determine that clear and express words would have been necessary for either party to have been able to bring what was otherwise to be a released claim. If no such express wording was present, that meant no such released claim could be brought. The causes of action that gave rise to the dispute had merged into the terms of the settlement agreement, and new obligations flowed from those terms. In my submission, the conclusions of His Honour Judge Dight in this respect, from paragraph 96 onwards of his judgment, were plainly correct. And I could, if I could invite the court just to turn to that judgment at page 123, it's behind tab 12. It's paragraphs 96, 97, 99, 100 and 102. If I could just invite the court to read those paragraphs. So, my lady, my lords, the appellant's case, simply put, is that His Honour Judge Dight's reasoning is correct. And if the court is against me on that, and it instead concludes that there is any reasonable debate as to the meaning of clause 7.2 and the reason for the inclusion of the admission of clause 4, then I would refer the court to the submissions I've already made about clause 4. And for those reasons, I say that the reasoning of Mr Justice Richards in relation to clause 4 is nonetheless wrong. The reason why express language would be needed to make clear that the landlord was preserving a right to forfeit by virtue of clause 4 goes back to the principle, as I've stated, of contra proferentum.
Is that a principle that's still applicable? And the other point arising out of that is, which way does it go? I mean, one of the principles that the courts now seem to formulate is that people don't give up valuable rights without clear words.
Well, but the clear words, my lord, are to be found in clause 6.
Yes, so you say and you point to the fact that Mr Bromino accepts that clause 6 is sufficiently clear to exclude.
So,
What about the point that a repairing obligation in a lease, such as clause 3, is a continuing obligation, so that a fresh breach may arise every day the property is out of repair? Does that have any bearing?
that doesn't have any bearing, my lord, because that was conceded at trial.
Right.
And His Honour Judge Dight did point to the fact that that might have been an argument that could have been raised but wasn't. So for that reason, that is not relevant today. I say that the principle of contra proferentum is still applicable in this case, and we know that the landlord accepts that their case is that clause 4 was inserted for their benefit.
Yeah.
So that being the case, I say it's straightforwardly the case that contra proferentum applies here. And if there's doubt, then any such doubt is to be resolved in favour of Mr White. Looking at paragraph 55 of the judgment of Mr Justice Richards at page 66, it's back to tab 7.
Yeah.
It's paragraph 55.
You've covered that in your East point.
Yes. Well, Ochubaga is authority for the proposition that there are other legal consequences of an admission, so that is why I say the judge has erred there. And then at paragraph 56, the third sentence reads, at the time of the settlement agreement, the landlord only had Mr White's word that he would perform the works as he had agreed to do. Well, in my submission, that reasoning ignores the fact that clause 10.1 of the settlement agreement provided that in the event of any breach on the part of Mr White would be liable to pay the landlord's costs on the indemnity basis. So it wasn't just a question of the landlord had his word, it was an enforceable agreement at law with what I say were pretty onerous cost consequences.
What does the judge mean by the landlord only had Mr White's word? Mr White has entered into an obligation to carry out a package of works by a particular date.
Yes, my lord, and with the stick that if he doesn't, it's going to be indemnity costs against him. So it's not simply his word.
Yeah.
And I say that the judge's reasoning wholly ignores the substantial payment of 75,000. And his findings at paragraph 57 fail to appreciate that. This court, may consider that the size of the payment itself is the objective reason for why the landlord would have given up the right to forfeit based on the outstanding disrepair here, especially when considered against the protection offered by the indemnity costs provision at 10.1. As I say, it's likely that at the FTT there wouldn't have been any costs order against Mr White. He would have just been, there would have simply been a determination that he owed the money and then he either paid it or they might have sued in the county court for debt. And as I set out in the passage that I cited from my skeleton argument, and this is back to tab 3, page 30. It's the passage from the Luck Oil Asia Pacific Limited and Ocean Tankers, the Ocean Neptune case.
Yes.
It's the bold section
Yeah.
at the end. The court must be alive to the possibility that one side may have agreed to something which, with hindsight, did not serve its interests. That might be the case here with Mr White having agreed to pay quite so much to the landlord. Similarly, the court must not lose sight of the possibility that a provision may be a negotiated compromise, and that is what I say is the case here. My lords, my lady, unless you wish me to do so, I don't intend to address the other areas of the judgment of Mr Justice Richard, as in my submission those are peripheral matters. And so unless I can assist you further, those are my submissions.
Thank you very much, Mr O'Grady. Economical. Yes, Mr Bromiley.
My lord, my lady, I will address the court primarily based upon my skeleton argument.
Yes.
But before I do that, I wonder if I could deal with a few points that my learned friend raised, particularly as two of them, as far as I can see, are completely novel, not canvassed in his skeleton argument. And it helps, I think, if I deal with them while I still remember what they are. The first was this point about the supposed value of the applications to the FTT when compared to the settlement sum. I agree as a matter of arithmetic that the sums, aggregate of the sums referred to in the service charge application and the administration charge application comes to just under £36,000. And as I understand it, my learned friend's argument is that given that Mr White agreed to pay £75,000, there is therefore a surplus which he must have paid in order to receive some benefit. My learned friend says that no order for costs would be made in the FTT applications themselves. And that is true, of course. The FTT is generally a no-cost jurisdiction. It has only limited powers to make awards of costs itself upon finding of unreasonableness. However, and because this is a normal point, not canvassed in the skeleton arguments, there's nothing on this before the court in abundance. But I would at the very least suggest that the costs of the applications to the FTT could well have been a factor in the parties coming to that figure of £75,000. I say that on the basis of the provisions of the lease. There are two provisions in the lease, which in my submission the landlord could potentially, at the very least, have relied upon in order to try and recover its costs of the FTT applications. The first of those is at clause 2.6 of the lease, and that can be found at page 5 of the supplementary one.
2.6.
Clause 2.6. This is a common provision which I'm sure the court would have seen before. It's a covenant by the tenant to pay unto the lessor all cost, charges and expenses, including but not limited to legal costs and surveyor's fees, which may be incurred by the lessor in connection with or incidental to any of the following matters, that is to say, the preparation and service of a notice under section 146 of the Law of Property Act 1925, whether incurred in or in contemplation of proceedings under sections 146 or 147 of that Act, notwithstanding forfeiture may be avoided otherwise than by relief granted by the court. Of course, this court decided in the decision of, I think it's Oram and 69 Marina, that taking proceedings such as section 1684 proceedings for determination can be acts taken in contemplation of the service of a section 146 notice. Because of course it is a necessary procedural hurdle in the absence of an admission before one can serve section 146 notice. So that clause in my submission would have, at the very least, given the landlord an argument as to why it would be entitled in due course, albeit not necessarily in those proceedings, to recover.
You'd have to
its
get another
costs.
determination from the FTT, would you?
Yes.
Yeah.
Ultimately, what would have to happen, if it hadn't in relation to costs, would be for the landlord to make a demand for payment, which would be an administration charge.
Right. Then go off the FTT
And
for
then go
determine.
off the FTT, and then of course one is left in the fractional position that you then have the cost of that application
Yeah.
to the FTT. You end up potentially with an endless string of applications.
So your proposition really is that at the moment of the settlement agreement, the landlord was not entitled to charge under clause 2.6, but might become entitled to charge in due course.
Yes, it was. It would have been the liability of the tenant would already have arisen once the landlord.
Well, the
having
contractual liability,
Yes.
but it's not an enforceable liability without a determination from the FTT.
No, in my submission, it would still be contractually enforceable. The further potential application of the FTT would arise if there was a dispute about the amount.
Right.
There would be various options open to the landlord. The landlord could simply bring a claim in debt in the county court for that sum and rely upon the clause in the lease. Of course, if the landlord did that and it was defended, it would go off to the FTT almost certainly in any event.
Mm.
So the other option for a landlord faced with a contested administration charge is do what the landlord did in this case.
Yeah.
Go off the FTT for a determination of liability to pay. But of course, that is not in my submission the only provision that the landlord could have relied upon in relation to costs, because cost clause 312(2) would also have been relevant in this context, and that can be found at page 9 of the supplementary bundle. And that's a covenant by the tenant to reimburse to the lessor on demand all fees, costs, charges, losses and expenses incurred or suffered by the lessor arising out of or in connection with or incidental to any breach of the covenants on the part of the lessee hereunder.
Yeah.
So legal expenses incurred as a result of the tenant's failure to pay service charges, administration charges, and a failure to comply with the repairing covenant, my submission could fall under those. So the position is not, there is no evidence about why the figure of £75,000 was in fact decided. All I'm trying to do here is illustrate the matter is not as clear cut as my learned friend suggests. Secondly, and as far as I'm aware for the first time today, my learned friend suggested that the settlement agreement did not in fact merely settle the proceedings, the 3 applications to the FTT, and any potential claims arising out of them, but also somehow was a settlement of an dispute about the insurance policy. That certainly wasn't argued at trial. I don't believe the point was taken in the first appeal. As far as I can see, this is the first time that has been suggested.
The insurance was maintained by the company, is that right?
Yes.
So they are the insured under the policy,
They are the insured.
and Mr. White is entitled to make a claim under that policy because?
I believe.
Is it joint insurance, or is he noted on the policy?
He's
Or
noted on the policy as
And
having an interest.
right, he's noted on the policy, and insurers accept that because he's noted on the policy, he can make a direct claim under the policy. Is that's the position?
I believe that is the position.
Yeah.
Certainly, Mr. White was dealing with the insurers
Right.
directly. But of course, if there was a dispute about that claim, it would have been either between Mr. White
And the insurer.
insurers.
I'm not sure what the landlord's doing in that
Indeed.
claim.
It is, I would suggest, perfectly understandable why, when Mr. White has undertaken in the settlement agreement to carry out extensive work to his bathroom, and he has made a claim under the insurance in relation to those works, so it's presumably hoping that the insurance will cover it.
Mm.
It is, in my submission, perfectly explicable why Mr White would not want the landlord sticking its nose in and interfering with that claim. But in my submission, that really takes the matter no further and sheds no light on what the proper interpretation of clause 7.2 is.
Yeah.
The last point, which I'll deal with by way of preliminary matters, is my learned friend's contra proferentum point, which is, I would submit, a canon of construction which is not.
Is a what?
It's a canon of construction which is not in favour these days.
Yeah.
But as I understand his argument, it was that clause 4 should be construed contra proferentum because it was included for our benefit. Well, I would accept, of course, that clause 4 of the settlement agreement was included for the benefit of the landlord. The tenant stood nothing to gain by making that admission. But the interpretation of clause 4 is not in dispute. Clause 4 is, whatever other defects the settlement agreement might have, clause 4 is, in my submission, perfectly clear. There is no need to apply the contra proferentum presumption or canon of construction to clause 4. Clause 4 is clear. The significance of clause 4 is not what does clause 4 say. The significance of clause 4 is whether its inclusion in the settlement agreement sheds any light on the proper interpretation of clause 7.2. So therefore, in my submission, the contra proferentum point simply does not arise. Now, I've started my skeleton argument with a summary of the background, both factually and procedurally, of the appeal. My learned friend, I think, covered those sufficiently. I don't think I need to take the court through that.
Right.
At paragraph 23 of my skeleton argument, I've summarised the grounds on which I say clause 7.2 should be given a broader meaning than that contained for by my learned friend.
Yeah.
And I propose to go through those grounds in the order set out in paragraph 23.
Yes.
And the first is the natural reading of clause 7.2. As you know from the authority, it's the starting point, it's the wording of the agreement itself. It isn't the end point, but it's the starting point. And so the issue is, what do the words in respect of any breach of this agreement mean? And in particular, is a forfeiture claim where the facts, the breach of covenant on which the forfeiture claim is based, is a breach of the settlement agreement, whether that forfeiture claim is a claim in respect of any breach of this agreement. And in my submission, yes, it should be. There's no reason to give it the narrow construction that my learned friend contends with. In paragraph 27 of my skeleton argument.
But if we just look at your particulars of claim for a moment, on page 146. Paragraph 4b, reason the claimant is asking for possession is the defendant's failed to keep the bathroom in his property in good and substantial and tenant repairs required by clause 3.1. That's not the settlement agreement, that's clause 3.1 of the lease.
Yes.
Then it goes on to talk about the settlement agreement, recites the admission, and clause 5.3. And then the final sentence is the defendant's failed to carry out the necessary remedial work and remains in breach of the terms of his lease. So that's a claim based on the lease,
Yeah.
not based on the settlement agreement.
No, absolutely. It is based on the lease, not the settlement agreement. I would accept that entirely. But in my submission, it is nonetheless a claim in respect of a breach of the agreement. Because the breach of covenant in the lease relied upon is a breach of the settlement agreement. It's capable of giving rise to a claim in forfeiture, not because of the settlement agreement, but because of the lease. But in my submission, it is nonetheless still a claim in respect of a breach of this agreement. Because the central facts on which the forfeiture claim is based are facts which are both a breach of the lease and a breach of the settlement agreement. But they are nonetheless a breach of the settlement agreement.
Yeah.
And that is the essential point about my argument about the natural interpretation. Is it a claim in respect of a breach of the settlement agreement? Yes. It is not a claim based on the settlement agreement. It is not a claim suing on. It is not a claim to directly enforce the settlement agreement. But it is, nonetheless, a claim in respect of a breach of the settlement agreement, because the essential facts on which the forfeiture claim was based was itself a breach of the settlement.
Yeah.
And my learned friend says, no, that can't be right. Plainly, clause 7.2 means something different. Although I didn't hear any reason as to why that plainly had to be. In my submission, at the very highest, clause 7.2 is open to multiple interpretations. And I say that with benefit of having two experienced judges having come to diametrically opposed interpretations of what it means. There is no clear, obvious and unequivocal interpretation of clause 7.2, not at least in this context. That's why I say the natural reading of clause 7.2 favours us. Not that it is the inevitable result of the wording of clause 7.2, simply that it is the natural reading of that provision.
Yeah.
I do also rely upon the fact that if my learned friend's proposed interpretation that the words in respect of a breach of this agreement means for a breach of this agreement, so directly enforcing this agreement, then clause 7.2 is entirely redundant. I accept, of course, that the presumption against surplusage may be given varying degrees of weight, and it is at its highest only a presumption. But if clause 7.2 says what my learned friend says, and all it says is that this is an enforceable agreement that can be enforced. That, in my submission, firstly, doesn't need to be said, but if it does need to be said, it's already said by clause 2, which says the parties hereby agree that this agreement shall immediately be fully and effectively binding on them.
Yeah.
Now, as I imagine the court's probably gathered by now, my submission is essentially that Justice David Richards got it right, that his reasoning is sound.
Jonathan Richards, I think.
Sorry?
Jonathan Richards, I think, not David.
Sorry, yes. Sorry, yes, quite right. That this court should adopt his reasoning. There is one point, however, where I would differ from his reasoning, and it is on this point. It's covered in Mr Justice Richards' judgment at paragraphs 41 to 43, and that's at page 64 of the core bundle. And in the final sentence, the judge said, one can quite envisage.
Sorry, of which paragraph? Oh, I see, 43, yep.
One can quite envisage a reasonable but pedantic reader of the settlement agreement asking whether the general exclusion in clause 6 prevented any claim from being brought for breach of the settlement agreement itself, and finding nothing unusual about that query being addressed expressly in clause 7.2. I would query whether such a pedantic reader would in fact be acting reasonably in those circumstances.
Right.
There could be no reason in the parties entering into a settlement agreement if it was not itself enforceable. In my submission, that would be an overly pedantic and unreasonable reader who would ask whether or not the settlement agreement was itself capable of enforcement. That then begs the question, well, if that question was unreasonable, then why is clause 7.2 there? If its only purpose is to say this contract is enforceable. It is not, I hasten to add, it's not a smoking gun, it's not a killer point. It is just another indication that the narrow interpretation that Malone Friend puts on those words is not the correct one when the contract is viewed as a whole.
Yeah.
The primary point on which Mr Justice Richards held that the broader interpretation of clause 7.2 is to be preferred was the existence of clause 4, which of course already been taken to. And I would accept, of course, in light of the authorities, that a person making an application for a determination of breach under section 1684 may do so for a number of potential reasons. In suggesting previously that there was only one possible explanation, I was overstating the position. There are a number of potential reasons. They are indeed identified in my Lord's judgment. In the East Point Block and Otterbark cases. And I would accept, of course, that a landlord, as here, making a section 1684 application for determination of breach might hope that either making that application or getting a determination from the tribunal might provoke the tenant into actually remedying that. That is undoubtedly an option. But in my submission, it's important to distinguish between two different questions. Firstly, first question is, why might a landlord bring a section 1684 application? Second question is, why is clause 4 contained in this agreement? Because the reasons why my client brought the section 1684 application, in my submission, aren't necessarily that relevant. The primary question, certainly, is why did it require clause 4 to be included in the settlement agreement? We know that it did make the application. Why did it include clause 4? And clause 4 can't have been for a claim for damages, because any claim for damages that the landlord had would have been settled under the settlement agreement. Couldn't have been a claim for debt in relation to the service charges or the administration charges, because again, those were settled by the settlement agreement. Similarly, any claim for an injunction arising out of the matters which were dealt with in the settlement agreement would have been in the proceedings.
Sorry, say that again? Any claim for
Any claim for an
injunction?
injunction
Yeah.
from the matters raised in the proceedings, the FGD proceedings, would have been settled by those proceedings. the landlord couldn't have,
It would be very unusual for a landlord to get an injunction against a tenant under a continuing obligation, wouldn't it?
it would, but I'm merely raising an injunction because
Yeah.
it's one of the possible explanations my own friend gave for the inclusion of clause 4. And I suppose in theory, a landlord could, having got a determination or admission of breach in a settlement agreement, go then off to court and get a declaration that a breach had occurred. I think my own friend originally referred to injunctions twice, and then under clarification referred to an injunction and a
You
declaration.
wouldn't need a declaration if you've got a determination by the FTT, would you? What
Or
would
an
a declaration add?
No, I mean, in my submission, if one went off to court and said, I'd like a declaration of something that the tenant's already
We're told you've got
admitted,"
one.
you say, why? It's not
Yeah.
necessary. So, can't be for damages, can't be for an injunction, which would be unlikely to be successful anyway, can't be for declaration, can't be simply in the hope that the tenant will actually remedy the defect because the tenant undertook to remedy the defect in the settlement agreement. So at this point in my submission, we're rather running out of reasons why the admission in clause 4 is in there. Can't be for damages, can't be for an injunction. Specific performance is not going to help. Declaration is unnecessary. In my submission, the only logical reason for its inclusion is in order to give the landlord the opportunity to bring forfeiture proceedings in the future and say, I've overcome the procedural hurdle presented by section 1684.
But section 168 doesn't entitle the landlord to bring forfeiture proceedings.
No.
All it does is entitle the landlord to serve a section 146 notice. What happens after that depends on all sorts of things, including, for instance, whether the breach has been waived.
Yes.
And here you've got a once-for-all breach, possibly.
In relation to the repairing covenant,
In
sorry,
relation to
Justice,
clause 5.3, a breach of that will be a once-for-all breach, quite capable of being waived. You've got the restrictions on forfeiture contained in the 1938 Act. So the last sentence, second sentence, or third sentence rather, of your paragraph 36 of your skeleton is wrong, isn't it?
paragraph 36.
You say the only legal effect of the application would have been to enable the respondent to bring forfeiture proceedings, seeking to forfeit the appellant's lease. So that's
That is wrong.
vastly oversimplified, if I may say so.
Your Lordship is entirely correct. It should say the only legal consequence is to allow the landlord to serve a section 146 notice. There are, of course, manifest hurdles to be faced even after that stage.
Yes.
The end result,
Might
the
or might
landlord
not be.
might hope,
Yeah.
would be forfeiture. But yes, there are, forfeiture is difficult. There are numerous hurdles put in the way, and they are only increasing. First of all, one has to get the determination of breach in the absence of an admission. Then you have to serve a section 146 notice. If the tenant serves a counter notice in the context of a repairing obligation under the 38 Act, then you have to get permission from the court to bring your forfeiture claim. And only at the end of all that stage can you actually get round to bringing a forfeiture.
Yeah.
It is. There are numerous statutory hurdles put in the way of a landlord seeking forfeit for perfectly good reasons.
And one would have thought at the date of the settlement agreement, anybody who thought about that would have thought that 999 out of 1,000 tenants would collect the benefit of the Act.
They might do, but as we know from this case,
Well, we know that
some
Mr
don't.
White didn't for, I don't myself understand why not, but he didn't. But that's just a windfall for landlords, isn't it?
It's unlikely, but it is not in my submission so unlikely that the landlord would say, oh well, because of the 38 Act, I won't bother seeking to forfeit. And in my submission, that's backed up by the fact that the section 1684 application was made. Because the same could be said of the section 1684 application.
Well, except that at the date when the 168 application is made, there are, as you will both agree, other potential reasons for making it. And at that stage, forfeiture is just a gleam in the distance because of all the hurdles that are put in the way of a landlord trying to forfeit a long lease of a residential flat.
It is agreed, yes. And of course, even if one gets a social forfeiture claim, the chances of relief not being granted are minuscule.
Absolutely.
But in my submission, the threat of forfeiture, the threat of that claim being brought, is nonetheless something that a sensible and competent landlord would, if possible, want to keep on their side.
Yeah.
Yes, ultimately, actually forfeiting the lease and the tenant not getting relief, almost impossible. But it's still the reason why we still have forfeiture, notwithstanding all the difficulties that are placed in the way of the landlord trying to forfeit a lease, is because it is nonetheless a useful tool in the landlord's armoury. And in my submission, that explains why clause 4 would have been included
Yes.
in the settlement agreement itself.
Yeah. So that brings you on to your clause 10.1 and 10.2 point, is it?
It does, my lord, yes.
Yeah.
And I would have to accept that this agreement, like so many others, could have been drafted better. But of course, it's always easier to draft documents with the benefit of hindsight than at the time. Clause 10.1 is not clear. Clause 10.1 appears at page 131 of the core bondage and is concerned with indemnities. And it says, Party B, and that of course is Mr White, hereby indemnifies and shall keep indemnified Party A against all costs and damages, including the entire legal expenses of Party A, incurred in all future actions, claims and proceedings in respect of the proceedings which it or its related parties or any of them may bring against the other party or its related parties or any of them. Now, there are two fundamental issues with clause 10.1. I don't want to dwell into too length because a detailed analysis of clause 10.1 is unnecessary. But there are two problems. The parties in this case were, of course, a company and an individual, Mr White. So there was an it and there was a he. But the latter part of clause 10.1 refers to proceedings which it may bring against the other party or its related parties or any of them. And one would assume that if you've got a company and a male adult individual, one of those should say he. It's also not clear which it is referred to. If one can accept that both Party A and Party B can both be referred to as it, it's not clear which it is being referred to by the use of those words in the second half of clause 10.1. So clause 10.1 is not clear. However,
But I mean, what I don't quite understand is how it's supposed to fit with clause 7.1. 7.1 says we won't sue.
Yeah.
10.1 says, well, if we do, you've got to pay our costs.
Yes.
Which seem to be directly contradictory. Then you get to 10.2, which is talking about a breach of this agreement, i.e. the settlement agreement, which makes a bit more sense.
yes, the only point that I seek to draw from clause 10, and why I say I don't think it's worth delving into its difficulties in too great depth, is the fact that clause 10.2 clearly anticipates, clearly covers situations where you are directly enforcing the settlement agreement. Clause 10.1, at its very lowest, anticipates that there may be other proceedings relating to this agreement, and uses the word
Which are not encompassed in clause 7. 7.1.
no.
What would they be? You've agreed not to sue.
Yes.
Any action, suit or other proceedings concerning the proceedings in this jurisdiction or any other. You've released clause 6, you've released any claim arising out of or connecting with the proceedings. So what indemnity is being contemplated by clause 10.1?
Well, one potential indemnity I would suggest is that, or one justification for clause 10.1 is that if one of the parties did breach clause 7.1 and sued the other party, then of course the defendant to that claim
I
could
see.
seek to have it struck out, could defend it on the basis that it's a breach of the settlement agreement, but would incur legal costs as a result. They could probably claim their legal costs as damages. They could try and claim their legal costs in that action, but
Yeah.
this provides a separate contractual
All
basis
right.
on the full
Yeah,
indemnity
all right,
basis
and I understand.
for recovering those costs. So I think that's the rationale for the inclusion of 10.1. But as I said, the only point that I draw from this is that the words "in respect of" are used in clause 10.1. Now they are not in respect of a breach of this settlement agreement. It's in respect of the proceedings. But it does clearly anticipate that there may well be or there might be. I don't think I can put it out. There might be proceedings relating to the proceedings which have been settled by the settlement agreement, which are not proceedings to directly enforce
Yeah.
the agreement itself.
Right.
There is then the point that I make at paragraph.
Sorry, paragraph.
51.
Yeah, that's the why not say it point. Any dispute on the interpretation of a contract, somebody who says that.
Absolutely. Because by definition, if you have a term that's ambiguous, it could have been drafted in the way that the other side say it should be read. It's a point that goes nowhere. I've tried to avoid making it myself, although I must confess I have in the past. My own friend has also referred to a passage in Foskett in his written submission.
Yeah.
He hasn't, I don't think, taken incorporation into all submissions, although criticises Mr Justice Richards for not having regard to it, so I think it's incumbent upon me to deal with it.
Yeah. It is usual, is it not, for a settlement agreement to wipe the slate clean of what's gone before and to impose a new package of obligations in place of those which had given rise to the cause of action that has now been settled.
Yes.
That's the general nature of a settlement agreement.
That's the general gist of it.
Yeah.
But in my submission, we're not so far removed from that. Because we couldn't have brought a claim in relation to a breach of the repairing covenant, whether by forfeiture or otherwise, if Mr White had complied with his obligations under the settlement agreement. The only reason why the forfeiture clause the forfeiture claim was even a remote possibility was because Mr White didn't do so. The question then is, once Mr White has breached the terms of the agreement, what can we as a landlord do about it? Now, my own friend says we can bring a claim for damages, enforcing the settlement agreement, that's not a problem. An injunction, that's not a problem. Specific performance, that's not a problem. So why in that case, why is there this bright dividing line between those forms of relief and seeking to enforce it by way of forfeiture? There is, I would accept, a conceptual distinction between the two, because for damages, specific performance, injunction, you simply rely upon the settlement agreement itself, whereas the forfeiture claim was sort of a hybrid claim, relying on breach of the settlement agreement and the fact that that breach was also a breach of the terms of the lease. But in my submission, there is no reason why, under the terms of this settlement agreement, there should be a bright line between direct enforcement of the terms of the settlement agreement and enforcing it by some other means, such as relying upon the forfeiture clause in the lease.
Yeah.
As I say, I'm not suggesting for a moment that we were entitled to forfeit because of the breach of the settlement agreement alone. We were entitled to forfeit because there was an ongoing breach of the lease, which was also a breach of the settlement agreement, and that's why this claim, although not directly enforcing the settlement agreement, nonetheless fell into the exclusion in clause 7.2. In my submission, there are no special principles that are to be applied to the interpretation of settlement agreements. One, of course, looks at the fundamental rationale behind them, that they are simply a contract to be construed in the same way as any other one. And equally, in my submission, there's nothing to be gained by saying, well, this is a narrow clause or this is a wide clause. Yes, clause 6.1 is a wide clause drafted in broad terms. But that doesn't mean that an exception to that clause has to be construed narrowly. If anything, in my submission, it would suggest it should be construed broadly so that it matches clause 6.1. But in my submission, those sort of global descriptions, this is a broad clause, this is a narrow clause, aren't really of assistance. The issue is, what do the words mean? And what the words mean in the context of the agreement as a whole and in light of the factual matrix behind it. And also, my lady, I'm conscious that you've had the benefit of my skeleton argument. I don't want to repeat things that I've said in my skeleton argument, so unless I can be of any further assistance.
No, also very economical, Mr Browning. Thank you very much. Mr O'Grady, do you wish to reply?
Yes, my Lord, just to explain to the court that the reason why there was no analysis in my skeleton argument concerning all of those figures that I took the court through was that we only had the benefit for the first time of the content of the second and third applications when the respondent asked for them to be put in as a supplementary bundle before this court. We didn't actually have the benefit of those either at trial or on appeal in the High Court or at the time that the skeletons were filed. And there was just one reference I wanted to take the court to in cases of assistance. It's from the judgment of His Honour Judge Dight at tab 12, page 123. It's just paragraph 91. The claimant says that the failure to repair by 28th January gives rise to a right to make a claim in respect of a breach of this agreement. Mr Bromelow submitted orally that the expression in respect of is inherently wide, and he described those three words in closing as nebulous words capable of various interpretations, not limited to enforcement of the agreement itself. My learned friend said that I didn't make good the point as to why it should be a narrow construction. The point is, when one compares the words in respect of, in clause 7.2, with the words related to, which are in clause 6, if something is related to something, it is a much looser connection than if something is in respect of. And that simply flows from the meaning of those three words. Unless I can assist your lordships and your lady further.
No, well, thank you very much. We've got through this very rapidly. It will not surprise you to learn that since this is a second appeal, we will reserve our judgments. You will get a draft in the usual way. It comes with a fierce embargo, which means what it says, and it will be your opportunity to correct our English, but not our reasoning. And we would hope that in the light of the draft judgments, you will be able to agree an order disposing of the appeal. If you can't agree an order, please make short written submissions and we will make the form of order that we consider to be appropriate. The hand down of the judgment in due course will be electronic and by release to the National Archives, so there will be no need for any further attendance. Thank you both very much.
All rise if able.